on civil liberty, security, and law enforcement. We had this larger panel to begin the conversation. And the idea of this second panel is really to build upon the discussions that we had in the very first panel. This is a shorter panel. We are running a little, slightly, I would say, below the schedule, but the delay is not that bad. And I hope that the fact that we are having a Brazilian moderating the panel is something that would not improve the delay greatly, as well, you know, as stereotype goes. So our second panel is controversial top-level domain names, freedom of expression, and intellectual property rights. I'm Carlos Affonso, with 2 Fs, please, not to be mistaken with the prior, and I would say Carlos Affonso with just 1 F. As the lady at the hotel did quite some yesterday. But so the idea is to have in this panel Bertrand, Phil, and Milton in a very informal discussion that will build upon the conversation that we had in the first panel. What we're doing here is the following. We're having like our panelists having short remarks that up to 10 minutes, I'll say like 5 to 10 minutes. And then after they made their introductory remarks, we go around the table to see the reactions that our panelist has to each other's presentations, and then we open up for Q&A. Okay? So I'm going to follow the same order that we have here in our program. So I'll ask Bertrand to begin the conversation. I'm quite sure that most of you know Bertrand, but he's the director of the Internet and Jurisdiction project at the International Diplomatic Academy in Paris, and he's also a director of the ICANN board since 2010. So, Bertrand, if you could start.
Thank you. It's a great pleasure to be here at the NCUC event. I hope there will be many returns of the day. It's a great exercise. I was in the previous one. The topic that we are addressing here is a very broad topic, and I'd like to narrow it a little bit and focus on some of the things that I'm particularly developing in the Internet and Jurisdiction project. Of course, what I'm going to say here is not an authoritative position of the ICANN board, and I'm mostly speaking here on my personal behalf. The challenge that we're facing in many respects regarding freedom of expression, intellectual property rights, but also many other topics, is a challenge of jurisdiction. We have a system that is basically in tension at the moment between the great quality of the Internet, which is to be cross-border, and to have cross-border platforms, cross-border infrastructure, and an international system of jurisdictions and a legal system that is based on the borders of the national territories. Let's call it, to make it simple, the Westphalian system that's basically based on national sovereignty. The challenge is that this tension is bringing many difficulties. You get platforms that host content, and I'm talking mostly about social media platforms and with user-generated content, that aim to have as broad and as cross-border an impact as possible. And for that, they have terms of service that regulate more or less what people can do on those platforms. And at the same time, you have a problem, which is that there is a patchwork of national jurisdictions. And this patchwork of national jurisdiction is not only a patchwork of 190 plus national jurisdictions, laws, or courts. It is also a patchwork that can be subnational. And I give you one concrete example. As we're in Canada, the province of Alberta in Canada has ruled a couple of months ago that the coupons from Groupon are not in conformity with the laws of the province of Alberta regarding vouchers. Which is wonderful, because if you're a global platform, you don't have only to address the complexity of 190 national laws, but to deal with the sub-national laws in every single federal state. And you know that, for instance, in Germany, the the privacy commissioners are on a land-by-land basis. And some of them have been extremely vocal, for instance, regarding things that apply to Facebook. So this, as an introduction, is to say that this tension between the two is also a problem. I mean, the horizontal normative order of platforms and the vertical normative order of the countries, it is also a challenge for countries. Because on the one hand, they try to assert jurisdiction and the respect of their national laws, which they cannot always enforce. And those who can enforce them sometimes have spillover effects on other countries, which is a little bit problematic in the so-called Westphalian system, where you're not supposed to have an impact on somebody else's territory. And so this tension is giving rise to two sets of problems. One is this question of the extraterritorial extension of sovereignty. And for those of you who were in the previous panel or attended the previous panel, I touched upon it briefly in that you have the extension of the national laws based on the location of DNS operators. And this transborder impact is very important, and one of the avenues that need to be explored is what is the responsibility of states that is the counterpart of their sovereignty. Because whenever a government takes a decision at the national level that has an impact on other territories, this impact needs to be taken into account. And you may know that, in particular, the Council of Europe, at the beginning of this year, has adopted, the Council of Ministers of the Council of Europe has adopted a recommendation on the universality of the Internet that embeds a principle of no transboundary harm, i.e., states should not take measures that negatively impact the access or use of the Internet in other countries. I won't develop it now, and we can talk further about it. I'm pretty happy about this thing, which, by the way, was proposed by a multi-stakeholder small drafting group, to which I was, with Wolfgang and Kleinwächter and a few others, proud to be part of. And we are seeing the potential for this principle to spread in order to balance the principle of sovereignty, the legitimate principle of sovereignty, with the also legitimate principle of responsibility. The second track that I want to highlight that is also directly related to freedom of expression is the question of the procedures that are being developed either in platforms, in their terms of service or in their internal methods, or by governments to handle those kinds of requests that we were talking about in the previous panel. It can be seizure of domain names, it can be notice and take down or stay down, it can be law enforcement access to privacy data. And one of the big challenges is that today, the processes that are in place in the intermediaries or in the platforms, the processes that are used by the governments are usually not enough documented, they're not enough transparent, they're not enough accountable, because in many cases they've been developed a bit ad hoc. And worst of all, or most important of all, they are not really well interoperable, i.e., because they're not documented, you get platforms who get requests that are not documented. They don't explain what is the legal basis for the request, what is the procedure that has been followed, and so on. And likewise, a lot of platforms are taking, on a day-to-day basis, decisions either to respond to those requests or to implement their own terms of service that are a little bit ad hoc and not necessarily documented in due process and so on. And what I found very interesting is that in the meeting we organized in Stanford a couple of weeks ago that I was alluding to before, there was a strong desire and a strong agreement on a notion, which is it would be great to develop a better interoperability and documentation for those processes, under the code word of procedural interfaces, so that, for instance, whenever there are requests that are being transmitted to intermediaries, they are properly documented, and that on the other hand, when they are processed in the platforms, the principles, or some of the principles among which you can include the ones that Cathy Kleiman was mentioning, those principles are taken into account, i.e., there's transparency, there's accountability. And more than anything, there's this notion of granularity. And the final point, not to use too much time, which is a direct connection to the fact that we are at an ICANN meeting and the domain name system, is that the whole debate about freedom of expression has one fundamental driver for me, which is this notion of proportionality and granularity. Due process is fundamental, transparency and everything. But one of the fundamental issues is the question of granularity. And to make sure that whatever measure is being taken is taken at the lowest level of impact possible, so that there are as little unintended consequences as possible. The notion that you must weigh in the unintended consequences is a fundamental principle that we all need to have in mind. And again, as I said in the previous interventions, I am extremely happy that the SAC has produced this document on blocking and filtering, because we are seeing at the moment a coming back of a lot of very high-profile freedom of expression issues, as you've seen in the last few months. And we need to design very good procedural methods to make sure that when we deal with this diversity of laws and partial accessibility or non-accessibility of content, we do it in a way that is a global due process standard. And I want to highlight one danger, which is that around this notion of hate speech, we used to have a general issue, which is the internet is making access to hate speech almost haphazardly more frequent. Like you're just going on the internet and then you see something that you don't like. That's one thing. What is happening today is the purposeful leverage of this global infrastructure to spread hate speech as much as possible and to produce physical impacts in countries, like tensions between communities. And it's a problem that, as was said in the introductory keynote, needs to be addressed. Otherwise, it's going to be handled under the label of cybersecurity, surveillance, and so on. And if the global community, including civil society, but also business and governments, those who care about due process, do not get together to manage to find the right procedures, then the wrong procedures are going to be used. And so that's where I want to end.
Thank you, Bertrand, for your introductory remarks. I would now give the floor to Philip Corwin. Phil is the founder of Virtual Law, a Washington, D.C. consulting firm specialized in assisting clients in shaping public policy. Phil has been, in addition to that, Washington-focused legislative and regulatory work that he also represents clients in proceedings of ICANNs in regard to policies governing the domain name system. So, Phil, you have the floor for up to 10 minutes as well.
Well, thank you, Carlos, and my thanks to NCUC for inviting me to be part of this excellent event today. In the outset, I want to say that whatever I'm saying here is personal views. I will refer at times to positions and postings on the website of the Internet Commerce Association. That's internetcommerce.org, which is a trade group of domain investors and developers that I represent. ICA is a member of ICANN's business constituency. So when I refer to that, that's referring to an ICA position. But overall, it's going to be easier for all of us. I just say that most of this is personal views. Starting out, and I'm going to be addressing primarily the new rights protection measures, the so-called RPMs for new generic top-level domains. We're discussing this as the tail end of the year, but this is still the year in which SOPA went down in the U.S. Congress because of an unprecedented protest engineered by internet companies and netizens against that legislation because it provided inadequate due process rights for domain registrants, and to some extent the issues where we become concerned with the issues raised by the new RPMs, particularly Uniform Rapid Suspension, URS, is where it starts to merge into SOPA, which is basically suspension, or in some it was called censorship of a domain without adequate due process for a registrant. And while the SOPA debate was primarily focused on copyright, in fact, SOPA also allowed domain suspension based on claims of trademark rights. In fact, ICA was the only group to send a letter to congressional leaders pointing out that the legislation could have been read to permit suspension of domains for the supposed new offense of a domain constituting a counterfeit mark in and of itself. Fortunately, the legislation went down, and I don't expect to see quite that approach brought back to Congress. And to put trademarks in suspension, because trademarks are the primary right we're looking at in new rights protection, at least in the United States, where I practice law and work with the national legislature and the executive branch, the legal basis for trademarks, although it's lumped in with intellectual property, it's of a somewhat different species than patents and copyrights. The power for Congress to provide for copyright and patent law is based in the U.S. Constitution, and it's a specific provision where the end of copyright and patents is to promote the progress of science and the useful arts by giving creators and inventors limited monopolies for a limited term to provide them an economic incentive to create the new inventions which in fact create the modern world as it moves along, the things that this microphone, our laptops, everything's a bundle of patents. And of course, copyrights are the things that enrich our lives, the movies, the novels, the poetry, all the creative works, and that's a good thing. The basis of trademark law, and trademark is important, but it's somewhat different. It's based not in that provision of the Constitution, but in the civil law, going back further. It's about commercial speech, and the primary object is not to protect the rights holders, but to protect the public by providing a reliable source, a reliable mark of source identification so they know that when they're paying to buy a certain brand, that it is in fact the brand and not a counterfeit and not a competitor of the brand owner. So the debate, and it's been a long and somewhat contentious debate in ICANN over these new RPMs, which go considerably beyond what's available in the incumbent generic top-level domains like .com, is what protection should be provided to trademark owners for the benefit of consumers. It's about protecting consumers in the end and protecting the rights of trademark owners. And it's been a process that went on within ICANN for over 2 years. There were multiple iterations. There was the IRT and the STIRT, and then it was reviewed by the GNSO, and then it was adopted by the board. And yet we still get calls for, at this point in time, not for implementation of the existing model of the trademark protections, but for substantial changes in their substance, which brings really to the forefront the question of how many bites at the apple does the trademark community, the brand community, get before new TLDs launch. Maybe it's time to launch them with the existing model and see what actually happens. I happen to think that .com is not the model for what can be expected with cyber squatting. The real model is in the various CCTLDs, which have been repurposed for general purposes over the past few years, like .me and .co, etc. And the actual incidence of cyber squatting and other bad practices has been quite low because, frankly, the practices that thrive at .com because of its dominance and because of the tremendous amount of type-in traffic to .com websites doesn't exist in these other TLDs, and is very unlikely to exist in most of the new TLDs. So I think the concerns, while they're legitimate, they're somewhat inflated about what is going to happen, and we don't want the trademark protections to be so oppressive that they deter registrants from using the two TLDs, and that they're counter to the overall purpose of the program, which is to foster competition and innovation. Now, before hitting new TLDs, I want to make note of one very significant thing that happened last week. Assistant Secretary Lauren Strickling, who's the person at the U.S. Department of Commerce with oversight of ICANN activities, sent a letter to Steve Crocker, chairman of ICANN's board, in which he said two big statements, and I wrote about this at the internetcommerce.org website. The first was suggesting that ICANN should explore new trademark protections for incumbent TLDs in the coming year. Now, I got to say, that shocked the hell out of me, because NCUC and ICA had both been in favor of going forward with a UDRP PDP for UDRP reform. UDRP is the only major ICANN policy that has never been reviewed since it was established. And the GNSO decided in December of last year to defer even procedural review until 18 months after the launch of new TLDs. The theory coming from the GAC and rights holder who thought ICANN was incapable of, as we say in the U.S., walking and chewing gum at the same time, that the focus on new TLDs was going to be so all pervasive that we couldn't even have a group looking at the UDRP and how it was functioning simultaneously. I didn't buy that argument, but the GNSO made that decision on the basis of they wanted to review the new rights protections before launching that effort. So the question comes to mind is, what is the GNSO, what is ICANN going to do with this suggestion? It's fine with me if they want to look at procedural changes to UDRP. From the perspective of the domain registrants, there's plenty of UDRP issues to look at right now. But if they want to look at substance of additional rights protections, I don't see how we can possibly do that until we see how the new RPMs perform at the new TLDs. I think it would be unwise to launch into that. The second thing the Strickling letter suggested was adopting the proposal we've seen from WIPO and from certain brand interests for a default judgment URS, and that's something that ICA and others strongly oppose. That would mean that where the registrant doesn't respond to the URS in the truncated 14-day period that they have, because the board has already reduced that period under GAC pressure last year, that the complainant would automatically win. And that means that no human would be involved in looking at, one, whether the rights holder actually possessed the rights they claims. And we've seen UDRPs where rights holders actually got domains in which they had no rights, which is one of the reasons we need UDRP reform. And there'd be no one looking at the domain name saying, does this appear to be an incontrovertible black and white case of cyber squatting, which is the purpose of the URS as a narrow supplement to the UDRP. So we think some trademark expert has to be involved in at least asking those two basic questions. Are there rights, and is this black and white cyber squatting, that the failure to respond in 14 days shouldn't result in an automatic win and a suspension of the domain, or as some people called it, censorship of the domain. Now, with my remaining time, let me talk about, I just posted earlier this week at the ICA webpage something called the Domain Rights Dozen, which is, rather than responding to every new idea the brand community comes up with, we wanted to set a dozen principles for guiding our review of them. And I'm not going to recite all dozen in the short time I've left, but I'm going to hit a few. Our starting point is that domains, just like trademarks and other IP rights, constitute a bundle of valuable intangible rights, similar to IP rights, and that a reasonable balance must be struck between the respective and legitimate rights of domain registrants and trademark owners. That's the overarching principle, we think the historical accident that trademarks receded domains because commercial life has existed for hundreds of years in free market societies, and domain rights have only existed in the commercial internet for 15 years since it was open to commercial practice, shouldn't mean that trademarks automatically trump domain rights in every. There's got to be a reasonable balance. We're not for intentional infringement, but we are for a reasonable balance. Second, while the RPMs must be effective against bad actors, we agree with that. Their design and implementation should recognize that the vast majority of domain registrants are good actors and that they deserve adequate and substantive and procedural due process rights. Now, every year WIPO puts out a press release saying the previous year we had these many UDRP complaints filed and it's up from the previous year and therefore cyber squatting is increasing. They never mention that every year the percentage of UDR complaints as a percentage of all domains goes down and has been going down steadily year after year. And the actual incidence of UDRP complaints as a percentage of all domains registered on the internet is 1/200th of 1%. Now, I know UDRP cases do not represent the entirety of bad acts going on at domains. Let's say you multiplied it by 100, that would mean that 99.5% of all domains are not susceptible to UDRP takedown. So again, the vast majority, there are bad actors, but most registrants are not bad actors. Third, and I think this is very critical at this point where brand interests want to reopen the substance of the RPMs, is that ICANN's bottom-up multi-stakeholder process has to be respected, and there's got to be some finality to the ICANN process. The current RPMs were negotiated through 2+ years. They were unanimously adopted by the GNSO and the ICANN board, and there's got to be a damn good reason for reopening their substance at this point in time when we're trying to launch new TLDs. The fact that trademark interests didn't get everything they asked for is not a good enough reason, because it's a process of competing interests and competing perspectives. And one example is the ICANN board in another area where they succumbed to GAC pressure. They cut in half the number of domains that could be involved in a URS proceeding that would trigger a loser pays requirement. It's down now to 15. I think it started out at 29 or 30. We had brand interest now advocating that in every URS, even if there's a single domain involved, that there should be loser pays liability, which means the ordinary registrant has to pay the cost of the corporate complainant who's bringing the URS. That seems somewhat unbalanced. We think loser pays may be valid for cyber squatters, intentional cyber squatters, somebody with 15 domains. That's a good indication they're a bad actor. But a single domain, that goes too far. New RPMs should enforce and protect existing trademark rights but not create new rights. And we were very happy to see the new ICANN CEO, Fadi Shahadi, reiterate that principle in a letter he sent to congressional leaders a few weeks ago, and we wrote again about that on our website. And he stated that in opposition to the proposal from the brand community to expanding the Trademark Clearinghouse, the other major new RPM, from exact matches to trademarks to mark plus generic terms associated with a mark. He said that would be ICANN stepping into the legislative field and creating rights that did not exist in the trademark world. And I know there are other perspectives on that, but we think the principle is sound. And I've got 1 minute left, so let me just mention a couple other important ones. We've seen proposals for altering the URS based on cost considerations. One, the cost estimates we've gotten back from WIPO and NAF, the two leading UDRP providers. We think they're somewhat self-serving and that we need an actual market testing, and we want to see ICANN proactively promoting the RFI they put out for the URS to other potential providers. There's a lot of qualified arbitration providers in the world. And also cost considerations cannot be a rationale for degrading registrant rights below certain minimum requirements. And finally, and this applies to UDRP as well, U.S. providers must be placed under a binding standard contract. That's the only way to ensure uniformity, and we just think it's wrong for ICANN to empower UDRP providers and URS providers to transfer or extinguish, or in this case, suspend domains without putting those providers under a contract that assures uniformity and gives ICANN some enforcement mechanisms when folks go beyond that. And my last thought here, and really speaking for myself, trademarks are just part of the picture of consumer protection. There are other issues that are starting to get consideration here. One is, should corporations be allowed to apply for not just their trademark terms, but for generic terms as single registrant TLDs, which are closed off to the rest of the public? Is that promoting competition and innovation? Another issue that I raised personally in an article published in June was whether the fact that the leading internet search provider, Google, and the leading internet e-retailer, Amazon, are the number 2 and 3 applicants, and whether that raises antitrust issues in the URS or competition issues in the European community. I don't know whether they do or not, but I think it at least may be an issue in their very extensive generic term application. So trademark is just one part of an overall picture of consumer protection, and I'll stop right there. Thanks.
Thank you, Phil, for those very insightful comments, and I believe I'm sorry to be a little bit draconic here in the control of time, but this is just to ensure that we are going to have the proper discussion that those issues, they do deserve. So I'm introducing now Milton Miller. I believe most of you know him, as Milton was the first to speak in our events earlier today. Milton's professor at Syracuse University School of Information Studies, one of the founders of the Internet Governance Project, and one of the founders of the NCUC. A good thing, and Milton was talking about the ICANN meeting of '99. It's good to see some of those folks that were there in the foundation of NCUC together with us here in this event. It's some sort of a reunion. And Milton is as well one of the founders of NCUC. So Milton, you have the floor, up to 10 minutes, and then we go back to some reactions from our panelists. Okay?
Great, thank you, Carlos. My topic is the free expression implications of the new TLD program. Now, some of you are probably vaguely aware of the fact that there are 1,900 strings, top-level domain names, being applied for out there, and that it has taken ICANN 13 years to get to the point where they could actually sort of, kind of, finish this process off, although, as Phil started to intimate, people keep trying to change it or add to it as we go along. But one of the things that's gotten added in the so-called end game is the GAC objection procedure. GAC is the... How many of you are here from the GAC? Aha, we have a hand. Yes. No, not many governmental people here, as usual. Yes, we did. So what happens is that you make an application, one of these 1,900 applications, that says, I want let's say, WTF. And then ICANN puts this application up on a platform where people can comment about it. Now, this to me raises the distinction, a very important distinction, between two paradigms of the new TLD process. I call them the objective standards paradigm and the community veto paradigm. So the objective standards paradigm says people apply for top-level domains, and ICANN and its policy-making process in advance and as clearly as possible tells them what top-level domains will be allowed and which ones will not. And maybe the people who are applying can make their best judgment as to what is not allowed and therefore avoid those applications and avoid wasting everybody's time. And if an application meets those standards, it succeeds. If it violates those standards, it fails. Now, the community veto paradigm is you put them up there, and then you ask people to say what they think about them. And everybody says, I like this, or I don't like this. Maybe because you don't like .wtf because it has some kind of implication of the F word in it. Or maybe you don't like what was the one, Yunnan. The province of Yunnan didn't like a particular domain because there is a small region of their province that is named that. Or the Argentinians don't like .Patagonia because, my God, that's an issue of national sovereignty, isn't it? Of course, to the brand owner that applied for that, it's an issue of trademark rights, or at least a trademark rights extension. So the point is, if enough people make enough noise, the implied standard here is if enough people make enough noise, they can block an application for any reason. It doesn't have to be specified. It doesn't have to be legal or illegal. It can simply be threatened by the fact that a lot of people don't like it. Now, to people who believe in freedom of expression, that whole standard, the community veto standard, is completely problematic. It's anti-freedom at its core. It's sort of like asking everybody in the room, do you think Bertrand should be wearing that tie? How many people don't like his tie? Oh, come on, come on. We hate this tie. We want him to change that tie. All right.
Should he be wearing a tie at all?
Yes, right. Should he be wearing clothes? Let's have the mob strip him.
Going in a weird direction.
No. It's, the point is, the community veto paradigm is kind of like mob rule in a sense that if the mob decides that they don't like something, or they're egged on by people who to tell them not to like something, then it gets killed, right? And I think, unfortunately, the biggest advocate of the community veto's paradigm is precisely the entities who should be the most strong believers in objective standards, that is to say, governments. Now, governments did this precisely because they were unable to come up with objective standards that would allow them to veto top-level domains. They basically admitted it. They first tried to come up with standards based on international law concepts of what was it? Morality and public order, yes. The famous MAPO, or as the illustrious Suzanne Sen used to say, MOPO, probably because it sounded more like mofo. But anyway, they couldn't. The U.S. government actually did a 180-degree turn on this, first insisting that ICANN have a MOPO standard, and then in Belgium a few years ago, their lawyers studied the issue and discovered suddenly that the law that they were citing did not give them the right to veto terms based on morality and public order. On the contrary, it simply exempted certain things from being recognized as trademarks. So they basically said, we ought to be able to object to things for any reason. And again, I think this is not what we want to do. This is against freedom of expression. It's not what we want Internet governance authorities to be doing. The Internet has thrived because it didn't have these kinds of permissions required. The idea is that you allow things and then you punish or stop or take down the things that are illegal or bad. You don't decide in advance what you're going to allow. We don't have votes or community consensus on whether our website should be allowed. You don't have votes or community consensus on whether, somebody gets a .com domain name before they get it. And that's a good thing. So I think this is a kind of censorship. It's prior restraint. It's worse because it's censorship with no legal basis. There is no universally recognized international law regarding acceptable DNS labels. There simply isn't. There is no due process here. There's no documented harm. There's no specific rights associated with the objector. It's just, I don't like it. So the essence of liberal democratic government is that the exercise of this kind of power, coercive power, is regulated and controlled. And when we institute these kinds of community veto standards, we are deviating from that in a way that is very worrisome to me. That's my comment.
Thank you, Milton. I'll just go through our panelists to see if you guys have any reaction on each other's presentations before we open up for Q&A and before we go out to lunchtime. So I will go through the order that we made the presentations. So Bertrand, do you have any reactions to Phil's and Milton's presentation?
Yeah, thank you, Carlos. Not so much to Phil's. I listened with great interest, and I must say that on a personal basis, I agree with a lot of the arguments. One point I would like to come to is more on Milton's angle. One of the big challenge is how to handle the rule regarding what should get in the root or not. As you know, the root is a authoritative database that is managed in the global public interest by ICANN, meaning through ICANN processes by the community. The thing is, as the discussion in the preparation of the applicant guidebook showed, the challenge is that there are two extreme positions that you can defend here regarding what should or should not get in the root as a top-level domain. One extreme is to say anything that is accepted in one country, if we just talk about country, should be allowed to get in the root, i.e. the most liberal position of all rules. The other extreme being, if something is not accepted by one country, it should not get into the root. The big challenge is, as Milton rightly said, is that we do not have commonly agreed standards for what the community as a whole considers overall principles. There are no objective standards. And you know what? This is what ICANN is about. That's what it is about. It's to allow all actors to define their common rules. It may sound ambitious, but that's what we're here for. Because the problem that we have is that if we want to be fair, we need to recognize that, yes, we must absolutely defend freedom of expression, capacity to have also, as I said, freedom of association, freedom of circulation. I see blocking as an embodiment, or, something that is preventing what could be called cyber travel. In the Universal Declaration of Human Rights, you have the right to leave your country and come back to it. When you're using a VPN, when you are using a domain name, you are moving to another jurisdiction or territory sometimes. But the point I want to make is, between those two extremes, the challenge is, what do we accept in common as this common tool in a community that is not the ICANN community only? It's 2 billion, 2.5 billion, 3 billion, 4 billion in the future, who do not necessarily share the same principles, the same values, and the same references or the same sensitivities. I'm not arguing whether it is good or bad, but this is the challenge that we're confronted with. And the problem we're facing is there are opposing forces. Some forces say the solution is very simple. It's separation. It's the traditional jurisdictional model. A jurisdiction is a separation. It's my law here and your law there. No interface. And there are people who say, I don't care what you do with your system. On my system, there is no such thing, and I want actually a bunch of national internets that will be interconnected. And where I have a problem on a personal basis is that sometimes the people who push very legitimately the most for the acceptance of every single word, every single content, and so on, and I insist legitimately, run the risk of producing the exact reverse situation whereby it emboldens those who say, screw you, you do whatever you want in your part, we're going to do whatever we want in our part. And the very, very big challenge is a matter of time. I strongly believe that in the course of time, some adjustment will happen, that people will accept more the diversity of issues, that they will find ways to identify the zones that they still want to go to, but they know what is on the other side. Like, if you're going to that site, you know, and you should be aware that this is going to offend you regarding the criteria you have set up. So don't complain if you get on the other side and you're offended. You're not forced to go there. But freedom of circulation is important. So I believe in the long term, people will agree on norms. And again, ICANN is there to develop this. The problem is speed. It takes time. And at the moment, we're confronted with a lot of issues where we have to find solutions on an ad hoc basis. And in the case of the new TLD program, we'll see how it pans out. So far, I'm not too scared about the chilling effects regarding people who would have wanted to do an application for top-level domains. We'll see how it works. But the great thing is, in a certain way, the governments, through the GAC, have accepted not to have the final word because the processes are incorporating them. But it's a very long discussion on the role of the GAC, and Milton and I have had this discussion for a while. But I see progress here in the respective responsibilities. And sorry I've been too long.
No problem. Thanks, Bertrand. And Milton gave me some head up here that he wants to comment on Bertrand's comments. So apologizing to Phil. So Milton, go ahead, and just to keep the conversation, just to keep the flow of the conversation going. A free flow of conversation.
Well, I mean, I'm not sure what the message is that we're getting from Bertrand, and that's the problem. In effect, I've heard this argument before that if we don't, as ICANN, veto or censor certain domains, then the internet will fragment. This is what we heard. And indeed, it is possible that certain countries will block certain domains, certain top-level domains that they don't like. Now, the argument is somewhat crazy in the sense that if you do that, if you block domains on the grounds that one country might block them, then you are reverting to that extreme that you defined of one country defining what's acceptable for the entire world. I'm not saying you're advocating that, but I'm saying that it's very easy to slip into that in certain cases by saying, oh my God, if we don't block this for everybody, then this country or that country will block it for their citizens. And I say, so what? In case you haven't noticed, they're doing that. And think of what the implications of that argument, what it means for websites. Forget about domains. If you're saying, because China would block Facebook, let's have a global committee that sort of decides whether Facebook should be allowed to exist or not. And we'll try to be a little more liberal than China, and we'll try to get everybody to get along, but no, that's just the wrong question for ICANN to be answering. ICANN should be saying, we're going to put domains up there that meet objective standards that we have negotiated through our own policy process. We accept the fact that some governments may take fragmentary actions. This is outside of our control. These are not actually threats to the internet, because people who take these secession actions are harming themselves more than they're harming anybody else, and they will quickly learn that. But ICANN should follow the objective standards paradigm. It has to. It is a global governance agency, and it has to completely err on the liberal or open side, because if it doesn't, it's exercising so much power that it's bound to be dragged into all kinds of content regulation issues.
Thanks, Milton. And Phil?
Yeah, just some quick comments here. In regard to Bertrand's statement, particularly regarding hate speech and national firewalls, I think there's got to be some recognition that the internet is different than traditional broadcasting, that with traditional broadcasting, although it's so varied today and there's so much more user control, but still you may be sitting there watching something and suddenly be exposed to something you weren't expecting, whereas the internet, the user has much more choice about which websites they're going to. And yes, the internet has allowed psychos and haters and all kinds of questionable people to find each other on a global basis and reinforce each other with sick ideas and hateful ideas. But, you know, I think being from the U.S., my general reaction is that unless there's an immediate attempt to incite to criminal or violent activity, I think the best response to that is more speech countering it rather than censorship. I think these national firewalls, the Great Firewall of China and other nations, I think these are the iron curtains of the digital age. We saw that when I was growing up, the communist regimes try to erect physical and other barriers, radio jamming, all kinds of things to keep their people in, prevent them from freely talking, prevent them from having access to information. I think that's what those attempts represent. I don't think most governments are going to go there. And fortunately, the internet allows people who want free access to information to find ways to root around those national attempts, even when they're living in a repressive regime. There's multiple examples of how they get around that. Milton's remarks on the GAC, you know, a lot of what's happening with the GAC and ICANN's reaction to it is, I think the elephant in the room is if you don't keep the GAC happy, the ITU is waiting to take over. So you need continued government support. I'm not sure how real that is, but I will say two things about the GAC, and I think I'm happy to see governments play a bigger role in the ICANN policymaking process. I think bringing them into the system is good for ICANN in the long run, but I think there's couple of questions here, one of which is if the GAC wants to be more involved, they've got to be more open and set up a process that's open to all perspectives. I think we saw on the rights protections, we saw some GAC members being very responsive to a message they heard from brand interests without trying to find out there was other points of view before they took positions within the GAC. I think GAC members need to take some responsibility to be fully informed on questions before taking positions. And I think there's a challenge for ICANN. I was speaking to someone who's on the GAC who pointed out that ICANN has said to the GAC, be more of a part of the GTLD policy process, but there's no real official role for the GAC within the DOS. So I think from the GAC's perspective, that's a legitimate concern. How do they plug into that process and shape policies while they're being made so they're not just in a position of objecting to decisions that have already been made? So I think there are, I'm happy to see the GAC more involved, but I think some questions need to be answered to make that involvement more effective and more reflective of the community point of view rather than just certain points of view.
Unless there are.
So, folks, just for a matter of time, just to let you guys know. So, we were scheduled to have our lunch at 12:45. As we are running a little bit late in the schedule, let's have 15 minutes at least for our Q&A so that we can go up to 1 p.m. Okay? So that will save us 15 minutes for Q&A, and then we go back to close our panel. Okay? So go ahead. Who wants to ask a question? So Bill, and we have some questions from the remote participation as well. Okay. So, Bill, as you already stand up, so I think
Apparently
you
I
go
have to do
first.
it this way?
Yep.
I'm Bill Drake from NCUC, and I was involved in the little group that was planning this event, and so I wanted to try to provoke you to discuss one topic that really didn't get aired as much as I would have liked. That is the controversy that has been going around with Michelle Nealon and people like that talking about the problem of, generic names like, book, et cetera, beauty, and so on, being gobbled up by the big brands, and how this feeds into a larger sort of trend towards enclosure and privatization of spaces in the net and all this kind of thing. This is a topic that actually cuts across the usual political alignments. I mean, there are people who are concerned about this who are not necessarily the same people who are concerned about some of the things like .wtf or something like that. And so, I mean, I think it's worth at least treating this seriously and addressing it. And it's been getting a lot of discussion, and I'm sure when we go to Baku for the IGF, we're going to be hearing about this more from governments and so on, and saying, well, you snooze, you lose. You weren't paying attention when we agreed all these rules, and now it's just going to go forward like this. There are a lot of parties who don't accept that. So it seems to me that this is something that merits at least some discussion in a forum like this. So I'd like to hear your views on it.
Well, actually, Bill, I did allude to that at the close of my remarks, but I think it's a valid. I think there are a number of unanticipated issues popping up that just weren't thought of as the TLD process was being designed, and it's I think if things weren't anticipated, it's perfectly reasonable to discuss them now. That's one of them. Should a entity be allowed to own a generic word, not a trademark of its own mark, but a generic word, and say, we're going to own it, but we're not going to let anybody register in it? I'm not sure how that promotes competition and innovation. I think there may be, as I mentioned, there may be antitrust or competition issues with the Google and Amazon bids for certain generic terms, like Amazon going after .shop and that's a closed registrant. I think there's another issue I didn't get to, and again, I think maybe worthy of consideration. There are bids in for generic terms for sectors that are regulated industries and professions with no requirement that a registrant be an accredited member of that profession or industry. And that's part of the consumer protection. That's a consumer protection issue that goes beyond the trademark area. So I think there are a number of things that just weren't thought of, which isn't surprising that we're seeing effects we didn't think. And should something be done? I'm not saying something should be done, but are they legitimate issues of discussion? Absolutely.
Could I jump in on this point?
Can just Milton wants to make some comments on the first question, and then we go through a round of comments so that we can get the remote participation, Avri's, and your comments as well. Okay. So
yeah, I'll be brief because the reason I have very strong opinions about this generic term issue also, but I didn't bring it up because it is indeed almost another panel in terms of the can of worms that you've opened, Bill. Yeah, so my opinion is that this is simply a business model choice, and that the people who are agitating about this are fundamentally registrars who want to see the generic terms opened up to their business model, and they want to deny the right of somebody operating a more vertically integrated business model, and that this is not an issue of competition. This is simply the type of competition that we're talking about. If Amazon wants to control the book namespace and run a bookstore that it manages, that's fine. If you don't like that, you can register the Latin word for books, or you can register book in another language, or you can register some other term that you can have books, book titles registered under on an open basis. I don't see it as any kind of a privatization of the word, because people assume that if you own .book, you're like, it's this old weird view that domain names actually are the world. And if you have .book, then you control the book market simply by having .book, which is just not true. If you have .book, you have .book. Let's see what you can do with it. You might fail, you might succeed, but there's no guarantee of anything there, and there are lots of alternatives. And by the way, books.com I like to point out, was controlled by a failing bookstore owner, Barnes & Noble, and it didn't do them a whole lot of good.
Thanks. Let me just go through. We have a round of questions slash comments just to get everyone to have a say. So, Avery, we have remote participation. Elliot, you want to jump in the line as well? If you want to come up with the mic and like make your comments, like feel free. So let me just go through the Avery and then remote participation, and if everyone else wants to make some comment, please just line up or show me a sign. Okay, so Avery.
Yeah. Hi, I'm Avery Doria from NCUC, and also coincidentally with this panel from .gay, which I'm very glad is not a controversial name. One of the things, and by the way, I agreed with Elliot and Milton completely on the dot book. On one of the things, Bertrand, that you said was that the GAC was not insisting that its opinions on what was to be, or its advice on what was to be blocked was not definitive. Yet, as far as I know, the applicant guidebook that was, I assume, approved by the board says it creates a presumption that it will be. So I don't quite understand the connection between a presumption that something will be blocked versus they accept that there is no such presumption. Thank you.
I have a question from Edward Morris, and it's a question relating to Bertrand's comments. And as we enter a world increasingly dominated by social media, a world where vanity URLs rather than domain names function as principal identifiers, how do we maintain relevance and relative effectiveness of the ICANN, the WHOIS, UDRP regime when malfeasors can simply migrate to social media platforms where, to date, platform terms of service agreements and not ICANN's consensus policies govern?
Let's go through some comments here on our panel, and I really would like to stimulate the people who are in the remote participation. You're doing quite well with the acronyms, but if you want like to send more questions with more acronyms, like you did very well with UDRP and other acronyms, by the end of the day you'll be like an expert in ICANN acronyms and stuff. But let me just refer back to our panelists. Okay.
Yeah.
Go ahead.
Well, I think I think that question points out something very important in regard to speech and freedom of expression. It's true, if you're on Twitter or Facebook or any other social media platform, you're bound by their terms of service. They reserve the right to change them at any moment, and you can have your identity and everything you've built around it taken down without prior notice if that's the way they've set it up. So a domain remains as long as you keep paying your registration fee. And as long as you don't violate the UDRP or now the URS, if it's a new TLD, you can do what you own your domain. You don't own your Twitter handle. You don't own your Facebook identity. So it provides a degree of independence that is not provided by social media. And that's why it's very important that the system remain open to individual users as an open platform for speech where they can't have somebody telling them, oh, what you just said violates our terms of service and we're taking away your ability to speak.
Awesome. I hope that satisfies Edward Morris. We actually have 15 people watching remotely, so thank you.
Yeah, a lot of points, starting from the last one, without repeating it too much. The question of platforms as digital territories, which is actually beyond the purview of ICANN per se, is an important issue. The terms of service are very, very important elements. And to throw sort of provocative wording, as I said in previous discussions, one of the key questions is what is the legal geography of cyberspace. Anybody who says that there are no frontiers in cyberspace is just purely wrong. There are frontiers. The question is, they do not map the physical frontiers. Sometimes they are larger. You have small countries that have a large impact because there are some operators based on their territory, and other countries that are very large and actually have no actor located there, and their sovereignty is shrinking. So the geography of cyberspace is a very interesting topic, and it's an opportunity for an advertisement for the Internet and Jurisdiction project, internetjurisdiction.net. And for those who will be in Baku, there will be 2 workshops on those topics that you are highly invited to come to. Second point, quickly. The word vanity URLs has been used, or social media identifiers. There has been an ongoing debate. That is a very valid debate, and I do not have a perfect answer to the question on, is the domain name still relevant? Will it be relevant in the future? People are using search engines, domain name in social media and so on, hashtags and so on. One of my responses is, and in here I somehow meet a portion of what Avery and Milton are saying, I do not believe, purely speaking personally, I do not believe that the big successes in the new TLD space are going to be the generic terms. Personal comment, just a suggestion. What I believe is that in due time, new TLDs that will come in, maybe not in that round, but maybe later on, will be under the hood. There will be machine-to-machine DNS interfaces that we will not see, but that will allow the interoperability of larger databases in ways that we don't imagine right now. As he said, it's not the .books or the hotel.com or the books.com that were the big successes of the web. It's been Google, Facebook, Amazon, and other new services. I believe that one of the strong benefits, and it's a bold bet, but I believe that one of the strong benefits of the new TLD program is that it will enable new services that we don't now know. At least that's what I hope. Coming to the question that was mentioned about if the GAC is not pleased, the ITU is going to take over. I want to make a very strong statement that I made in ICANN, that I made in the ITU before and so on. The Internet is an infrastructure that is based on a fundamental principle, which is the separation of layers. You can cut them in as many slices as you want, but just take a very simple model, which is the physical infrastructure, the logical infrastructure, and the application layer. ICANN and ITU inhabit different layers. The ITU is 100% legitimate in the infrastructure layer, promoting connectivity, distributed spectrum so that people can operate, activating dark fiber. There are hundreds of kilometers of dark fiber that are not activated in Africa because of snaffles between telecom operators. That's legitimate. They've been there for ages, and don't make a mistake. The ITU is going to be there for a long period of time. This is not the point. ICANN is inhabiting the logical infrastructure layer. The two may have overlaps. They have connections. They are separate. And this battle between one organization versus the other is a wrong battle. The right battle is how to make the multi-stakeholder approach be used in everything that deals with the Internet, including when we talk about the infrastructure layer. That's the right battle. Finally, still regarding the GAC, I understand Milton's position on the question of what gets into the root or not. I respect it very much. I mean, it needs to be defended. What I think is that with difficulties, ICANN, as a process, has managed to find some form of balance between the principle of openness to any application for the new top-level domain, which was not a given from the onset. It could have been done in a completely different manner, and the need to put in place a certain number of protections to ensure the acceptability by all. And in this regard, governments have participated in this exercise, and even if most of my ex-colleagues from the GAC don't like me saying this, national governments at the global level are extremely legitimate local authorities. And the coalition of all national governments does not in itself make a global public interest. This is very, very, very important. Governments so far have the monopoly of representation of their citizens. This monopoly is not appropriate anymore. There, however, still are very important actors in this discussion. And to answer Ivory's question, it is an amazing situation, honestly, that we could have a situation where the GAC relatively forcefully says, we think this TLD should not be accepted, and with very good reasons, the board, given different inputs or so, might in the end say, well, you know what, nonetheless, it will get in. The fact that this procedure is even explicitly envisaged, I believe, is a great win for the community and for all actors that have been involved in determining it. The fact that we have this, and it will be tested, is a great win.
Can I just...
Sorry, one last sentence on Bill's question. The only comment on this is, I do believe it is an important issue. I do not have a position on the question of the generic norms being used by one actor, but we need to ask the question of how do we discuss it? Because it is a question that people care about, and we cannot let it go and go and go until suddenly there's a problem with it that we don't know how to solve. So my question is, where do you want to discuss this, if you do want to discuss it? But it's not the board that is going to take it.
Thanks, Bertrand. We run out of time. Let me just go to the audience to see if we have one quick final question. Yep, go ahead. Very quick final question, and then we...
Yeah, I thought it was interesting that the way Milton sort of just laid out these two forms of decision making. One would be the sort of standard, universal standards or whatever, and implied standards, and the other being veto, coercive power of the veto. And I wonder which decision making within ICANN came out when the discussion about the Olympics names and the Red Cross, and was that coercive veto or standard in community standards?
Yeah, the Red Cross issue was really kind of separate because there was no application actually relevant to the Red Cross that was made. I think the existing standards that were objective, reasonably objective, would have allowed them to block any clearly offending top-level domain application. Because they do have all kinds of legal protections for those names. I think what Red Cross and the Olympic Committee were asking for was another step, a set of special protections that went beyond the ones that existed for everybody else, and that's where they broke down. So it wasn't really a community veto case. It wasn't really the application of an objective standard. The whole controversy was about them asking for even more. And part of the reason that demand was rejected was because we didn't know where it would stop in terms of the other international organizations and so on. I think we should eat.
Yeah. Well, Milton, thanks for that. Well, we reached our limit of 15-minute delay. I would like just to go through our panelists for very, very short, 30 seconds final remarks, and then we conclude our panel. So,
I want to thank NCUC again for inviting me to participate in this panel, and I hope that we provided food for thought as we look forward to the other kind of food.
We need more discussions like this in the normal meetings of ICANN.
Food, drink.
Robin, please, we have an announcement.
Thank you very much. I just wanted to let folks know the lunch is right out here. It's a buffet.